I'm Gary Burgess, and welcome to Holding Court, the Jersey Law Podcast. And today, we're talking about children. Joining me, my expert guide, Advocate Rose Colley, family law expert and partner at Viberts. Rose, it's great to see you again.
And you, Gary.
And it feels to me a subject area this time that is vast.
It is vast, and it's also the area that people see as the most important.
Because there are so many threads of our life through themes we've spoken about in this series, through cohabitation, through marriage, through divorce, where children come into play, their needs matter, their rights matter, but actually how these things work, perhaps are not always what people expect.
No, they're not. And very often, I think people forget that the decisions that they may make about their children, and particularly how they deal with the split, whatever, can obviously affect the children too for the rest of their lives.
And all of this, in terms of a legal underpinning in the island, is the Children Law Jersey 2005.
That's right.
Which was based on an England and Wales law dating back to 1989, I think it was.
That's correct, the Children Act.
And so have they kept pace with each other over time, or have they diverged? How does it work?
The answer is they haven't diverged. What has happened is that England and Wales, the Children Act has been amended numerous times as different things happen. Things that are seen as needing improving are improved. In Jersey, we're much, much slower to do that for all sorts of reasons to do with drafting the law, getting stuff through the states.
And I think it's very important at the outset. We'll go through lots of examples, lots of variables, lots of jargon that hopefully will make sense of for my benefit as well. But we're talking about private law cases when it comes to children in this context. Just explain the difference between that and a public law case.
What we're talking about here are the rights of children and their parents, where it's between the child and their mum and dad. So that's private law. What's called public law children cases is where the state intervenes. So what most people will know of as care proceedings.
So in this context, we are talking about that family unit.
Absolutely.
And how it interacts together in good times or bad for that matter. And a phrase I've heard before, and I suspect will come up in the course of our conversation, is parental responsibility, sometimes abbreviated as PR.
It is.
It sounds at face value a very Ron Seal phrase. It does what it says on the tin. It is parental responsibility. But actually,
it's much more complicated than that.
I knew you were going to say that, Rose. What is parental responsibility?
Well, parental responsibility was the new concept that came with the Children Act. And eventually we took on board in Jersey, as you said, in 2005. I always describe parental responsibility as the ability to hopefully agree on the big picture decisions about your child or your children. So it's things like education, serious medical treatment. It can be things such as religious upbringing. So it's these sort of big picture things rather than the things that are caring for the child from day to day. So it's not, for example, it's not does little Johnny learn to play the violin? It's does he go to De La Salle or Vic College?
And what if those parents are in conflict with each other on what they think the answer to that question is?
The answer is, unless they can reach an agreement, either without lawyers, with lawyers, mediation, without mediation, then the court will step in and say, this is the decision. And it's taken completely out of your hands.
So there is a lot of interest, I would have thought, from a pragmatic, what a parent wants point of view, to deal with these things as civilly, as pragmatically, as politely as you possibly can, and avoid it escalating?
Absolutely. But of course, that doesn't always happen. And you'd probably be amazed at the amount of case law there is about where little Jane goes to school. Does little Johnny have the vaccine, MMR, for example? They're the sort of things that people tend to get very, very emotional about, even down to do I allow my child to be christened? Or, yeah.
Are these the sorts of things that parents need to be thinking about up front, or are just these things that happen during the course of being a parent with your child and your child growing up and these events appearing on the horizon?
I think some of them probably could be thought through. For example, are our children going to be baptized or not? But I think some of them just sort of evolve. So when the child is born, you're probably not, hopefully, unless you want to put the child's name down for Eton, you're probably not thinking about what school do they go to, but some parents do. But it tends to be when people are no longer together that things that should be straightforward tend not to be straightforward. Sometimes they have financial implications, which were easier when they were together, for example, paying for school fees. But yeah, they are things that do gradually evolve over time.
And this might sound a silly question. Is parental responsibility something that goes to the birth parents of a child? Who has parental responsibility?
Well, the answer is, if you're married, you both have parental responsibility. And that's been the case since the children law came into force. If you're not married, if the child was born before the end of 2016, then the unmarried father does not automatically have parental responsibility. The mother does, but not the dad. After that date in 2016, as long as dad's name is on the birth certificate, he does have parental responsibility. But of course, there are still hundreds and hundreds of dads who don't have parental responsibility and sometimes don't realise that they don't until things go wrong for whatever reason.
And I think that's an important point, isn't it? That actually, for most of those dads, this isn't an issue in the first place, because actually we would hope for most there isn't an issue where this has to come up and be a thing. But there may be dads out there, when something goes wrong, they suddenly realise a right they assumed they had just doesn't exist.
I mean, probably the most common example of that is where a couple who are living together, dad may not have parental responsibility, they split up, and mum decides that she wants to permanently leave Jersey with little one or little ones. And if dad doesn't have parental responsibility and he doesn't make an application to the court, then mum removing the child is not actually doing anything wrong.
And so is that about the dad having to move quickly in that situation?
Absolutely.
And get across his legal rights and do those things?
He needs to make an application to the court in that situation. And even if he has parental responsibility, there are cases where he would still need to make an application to the court.
Goodness. I'm working my way through my little shopping list of things I've heard of. Another one is residence.
Yes.
What is residence?
Okay.
I've also heard sole residence and joint residence. Help me out, Rose. Help me out.
Well, residence, I guess, used to be, and some people still call it this, custody. There's no such concept as custody anymore. It's parental responsibility, and then who has the day-to-day care of the child or children is the resident parent. And either you can have just one resident parent, or more and more in this day and age, parents either agree or the court orders what's called joint or shared residence. And that doesn't necessarily mean that little Jane is with dad half the time and with mum half the time. It can be a sharing that isn't 50-50, but it does mean that effectively little Jane has two homes and two residences.
So it's as straightforward as that. And you're right. I've heard the phrase custody, and that means more to me. But again, as we spoke elsewhere in this series about common law marriage, doesn't exist. We're talking
doesn't
residence.
Exist anymore.
Right.
At least until, well, obviously until recently here, it did exist.
And as I work through my shopping list of phrases, another one I've heard of is contact, direct contact, indirect contact, supervised contact, unsupervised contact. I think it sounds pretty obvious, but what actually is it, and when does it apply?
Well, it used to be called access, and that's what lots of people still call it. But it's also the issue that probably causes the most arguments, the most cases before the court. And it's simply, when does the non-resident parent see their child? And obviously all circumstances are different, and you can never really have one size that fits all, but there can be a variety, as you've said, of different sorts of contact. You can have overnight contact, which is obvious. You can have direct contact, which doesn't involve overnight contact. You can have what's called supervised contact, which is where, for whatever reason, things have happened. Often it's linked to some form of domestic abuse. It means that someone has to make sure that within the contact session, certain things don't happen. Then you can have what's called indirect contact, which is effectively, well, in the past, it was always letterbox contact. So you were allowed to write letters and cards, maybe send 2 presents a year. Indirect contact now involves Zoom, FaceTime, all of these things that, only recently have started to happen. So there's a whole multitude of what arrangements can be made and what the court can eventually order.
And that is what I was going to ask you. Is this always the result of something that's had to go to court?
Not always. Many people agree these things. It's not always in a court order. But even if they agree things, they can still have them put in a court order without actually having a big dispute before the court. They can do things through what's called a consent order. And that can be useful. I mean, it can be particularly useful if the child has, say, got a different surname to dad, and dad wants to take the child to certain jurisdictions. Then very often dad will need to show the court order. So it can have practical uses
and that's
to get things agreed.
And that's really interesting what you were saying, though, that it's not necessarily about where there isn't an agreement. If mum and dad, if 2 parents have agreed, they can then get that translated into a court order to give it that formal underpinning.
They can, and it's fairly cheap and easy to do that.
What about when it doesn't go well? What about when there just isn't an agreement? How do the 2 tribes meet in the middle? How does that court order process work? Because it sounds to me it could be a highly emotive situation.
I mean, there are cases that go on for years and years and years, or cases where you think things have settled down and then there's another dispute. So it all comes back again. These are cases which are often called high conflict or complex cases to do with children, where the parents simply cannot agree. There are some parents, and it's sad. But there are some parents who can't agree on very much or anything. But often, as a family lawyer, you need to try and work out why can't they agree. So that often involves psychological reports, particularly on the parents, because this is where a family lawyer almost becomes like a psychologist. You have to think they may be having difficulties with relating to their children now because of difficulties that they suffered to do with attachment to their own parents. They may have been, for example, sexually abused as a child, which has this huge effect in terms of how they go on to parent their own children. So these cases are probably the saddest cases, but also they can be cases where domestic abuse is involved. And of course, nowadays we don't talk about domestic violence, which had this connotation of it just being physical. Domestic abuse, and there have been recent big cases in England and Wales on this, but domestic abuse can be a pattern of behaviour that's now been accepted by the courts, and it would be, I think, now accepted by the courts here. It can be controlling behaviour, so it might not be physical at all, but it could link into things like he or she controls my social media account, controls my finances, won't allow me to see my friends.
And when you start layering all of those details in, with a child at the heart of this, finding an agreement that pleases everyone, I mean, it feels like it's almost impossible to do.
I think in these very difficult cases, it can be very difficult to do. And the court in Jersey use an agency called JAFCAS, who are effectively the court welfare officers. And obviously they're trained social workers who specialise in this sort of work. And often you need to take things step by step. But you then start to stray into this territory of another thing that lots of people talk about is something called parental alienation that you've probably heard about, where little Johnny doesn't want to see you, but he doesn't want to see you because of the way Mum has told him certain things. For example, now there's a huge dispute as to whether parental alienation actually exists or not. Again, it tends not to exist just in a vacuum. If it does exist, it tends to be either because of, let's say, Mum's own psychological makeup or things that have happened to her within the relationship, which make her say things she knows she probably shouldn't say. And of course, some children pick up on things very quickly, depending on their age. And there are certain ages when, particularly when they're starting to move into their teens, when children can be really, really affected by this sort of conflict.
Just makes you feel sad, the thought of it. When it comes to, you spoke about some of these cases can be quite drawn out through the court process. There is still that child in the middle of this battle of wills going on. Is it that that child's life is on hold in the meantime? Is there an interim agreement of some access? You know, where do the child's rights sit in all of this?
There can be.
That could be a horrible situation.
And of course, the child's voice is supposed to be so important. But obviously with particularly young children, it's really difficult to know what their voice is, because their voice may simply be the voice of the resident parent. It may be that they don't want to choose between their parents. And very often, even slightly older children will say one thing to mum and one thing to dad.
Does the court listen to the child, or is it always the parents that the court is listening to?
The JAFCAS officer will always spend time with the child. Um, Sometimes the courts, again, perhaps with children 13, 14, 15, will actually ask the child if the child wants to have a fairly informal meeting.
So it doesn't have to feel like a formal court hearing. It's
No,
a
no, no,
chance for a
no.
conversation to eke out some of those thoughts. And it strikes me, hopefully, inject a little bit of common sense into
Yeah, and I
proceedings.
think that's really important. One, for the judge to meet particularly the older child, so you can then see that they are a real person. But also, I think the wishes of the child are so very important. And obviously, by the age of 13, 14, if they don't want to do something, so if they don't want to see dad, for example, it's going to be quite difficult unless they can be persuaded that it's for their own benefit that they do that.
In your experience, elsewhere in this series, we spoke about some long running divorces where, at the end of a very long process, the couple effectively say, if we knew then what we know now, we'd have got our act together sooner to
Mm,
save a lot of heartache
mm.
and money. Does the same happen in some of these drawn out cases with children as well? Or is it more emotional
I
because
think
there's
it
a
is
child?
much, much more emotional. And sometimes the child's voice isn't heard as much as it should be. And often, although the court tries very hard to remind the parents that this is about the child, often it can very sadly be more about the relationship that the two parents have had and all the things that went wrong and all the things that are still causing hurt and bitterness.
So that's a lot about the courts. Are there other avenues you could go down in terms of trying to resolve a dispute or to turn it on its head to try and reach a resolution?
Hmm. There's obviously in Jersey the family mediation process, which a couple of organisations do. And that can be, with children cases, very effective. And there's now something in Jersey called child inclusive mediation, where the mediators have also been trained to talk to children and to gather their views and then to try and mediate between the parents. And that can be really quite successful, but it tends not to be able to work very well in these most difficult of cases.
And is the route to those alternative routes generally having approached someone like you to begin that conversation?
Not necessarily, although I'd say a lot of cases do start that way. Very often things will have gone wrong. They take some legal advice, and one of the steps that's suggested is to try the mediation route because, as I've said, certainly in relation to children, it can be very effective.
What about some of the other issues that are thrown up around children about where they live? If there's a sort of push pull about wanting to live in another jurisdiction, I think we touched on a bit of
We
this
did,
earlier
yeah.
around vaccines, for example.
Yeah.
It's very topical. Should my child have a vaccine or not have a
Mm.
vaccine? Is there common ground in the approach of these, or are they all very distinct issues?
I mean, obviously, there are legal precedents. So the most common thing that probably comes before the court is the permanent removal from the jurisdiction, particularly, obviously, because we've now got so many people, not only from Portugal, Madeira, but Poland, Lithuania, Romania, etc. And very often they want to go back. They don't want to stay in Jersey for a whole multitude of reasons. Now, in those cases, it has to be in the best interest of the child as to whether or not the removal is allowed. But the problem with those cases is they're very, very horribly black and white. The court either says no or the court says yes. And it's really difficult to mediate those cases. A few you can, but normally you are very, very polarized in terms of, I want little Jack to stay here. I don't want him even to go to England or France, let alone further afield.
And the very nature of a case like that getting to court means that there will always be a disappointed party.
Absolutely. And those cases get more complicated when, so for example, dad might be Jersey born, English speaking, mum, for example, might be from Poland. The court then has to be really careful to make sure that if the child's allowed to move back to Poland with mum, that dad's rights of contact, of seeing the child, are maintained. And that can be even more difficult in very different legal jurisdictions. It's difficult enough between here and the UK, but it's even more difficult.
And that is something where you certainly would want to employ the services of a lawyer.
You certainly would, absolutely. But also you might need the services of a lawyer in that other jurisdiction. So, for example, if the court makes an order here, can the order be enforced in, let's say, Poland, for example? And then language difficulties obviously creep in, and it can be really quite problematic.
We've spoken a lot about the rights of a child, about the needs of a child, about hearing to an extent the wishes of a child in amongst all of this. What about just brutal finances and financial settlements around a child, particularly, I guess, around divorce proceedings? How does that work in principle?
It's not always. If you're married, the child maintenance or child periodical payments are dealt with within the divorce settlement, including things like school fees, who pays for holidays, potentially, that sort of thing. If you're not married, you have to use the children law, and there's something called Schedule 1, which does allow you to make financial provision for the child. And that can range from a monthly amount of maintenance that you pay. It could be a lump sum. And in cases where there's more money, it could be where, let's say dad, because very often it is dad, lends mum a larger sum of money to put towards a property, which then she doesn't keep, but she then has to give back at the point that the child very often leaves school or sometimes university.
And once that Schedule 1 is in place, can these things alter as perhaps the circumstance of a parent changes, or indeed the needs of a child changes?
There's always a review clause, but reviews of these things can be quite expensive. So it's always better, if you can, to try and think ahead and do things as clearly as you can. But one of the most difficult areas, because provision's always changing, is around the child going to university and what financial provision needs to be paid by mum, paid by dad. Because, of course, a few years ago, we didn't really have any grants, and now we do. And sometimes there's a student loan. There's this whole myriad of things that if you get divorced when the child is 3 or 4, you may not be able to think through. So you have to build in a review. But the review, let's say 10 years down the line, may be quite problematic. And if parents can't agree these things, then again, they may need to go to court in order to resolve it.
I suspect there are 1,000 more things in this area we can talk about. I'm scared of missing out something fundamental. I've been working through my little wish list. Is there anything obvious I've missed in this area? Because it feels like there's so much we could talk all day.
I think the only 2 things to mention, one of them we mentioned in a previous episode, and that was there is now this move in Jersey to give step-parents parental responsibility, which I think is an important change. But also the people that are often forgotten about are grandparents.
Of course.
Grandparents can make applications for contact very often, sometimes residence, under the children law, the only thing they have to do is get over an extra hurdle, which is the court has to give them what's called leave, which is they have to prove that they have a legitimate case to put. But yeah, there are cases that involve grandparents, and they tend to be very sad.
But there is a mechanism
But there
to
is a
try and find a
mechanism.
resolution to whatever the issue is.
But often, of course, they're the families that are completely split in terms of the child, and the child has even more sort of potential conflict to deal with.
It feels like in each of these episodes where I've asked you for your 3 top tips, that this is one where it could be very useful, because there are highly emotive and volatile issues at play potentially. So go on then, Rose. I'll put you on the spot again for such a huge area.
Yeah, it's
your
quite
3
difficult
top tips
with children. I would say, first of all, understand what parental responsibility means, understand what residence means. Try as far as you can to agree things, so don't argue about things like vaccines. Probably I would say the best parental arrangements are where there is some sort of shared residence arrangement, so the children feel secure having the 2 homes. So I think that's sort of one tip. I think the second tip is around being really careful and sensitive, and just being careful that there will be things that children will overhear. They will pick up your body language. They will pick up when you're stressed, and try not to tell them things like, Daddy hasn't paid the maintenance this month, or Daddy's threatening to take you away from your school, or that sort of thing. I think we as parents sometimes are not as careful as we should be. And we've probably all from time to time as parents been guilty of that. So I think that's the second thing. And I think the third thing is to try and think, this is your child. If you can't reach a civilized agreement, then these things will affect your child, and will potentially then affect your child when they have a child, because you can see these patterns in families that develop. And in these very split families, you can actually look at 2 or 3 generations of children who have very weak attachments to their parents, for example. They constantly feel caught in the middle. Their own parents may have difficulties with alcohol, drugs, for example. And it's just so sad how, as a family lawyer, you see these things just going round in circles. So again, just try and think, what is this doing for the child, not just today, but 10, 20 years down the line?
Brilliant, wise, human, no nonsense, empathetic advice.
Thank you.
I would expect nothing less from you. Advocate Rose Colley, partner at Viberts, thank you so much for joining us. Next time, a fascinating subject. We're talking social media and the traps that may lie before you on the next episode of Holding Court, the Jersey Law Podcast.